Good morning, everybody. Thank you for joining us for today's webinar. My name is Amber Hines, and I'm very excited about having a guest presenter, Attorney Mark Munson, with us today to talk about Medicaid planning with IRAs and qualified funds. Again, my name is Amber Hines, and I am the owner of Ashbur, where we specialize in immediate annuities that help clients qualify for Medicaid. And we have Mark Munson, who primarily practices in the state of Wisconsin, but he is licensed to practice law in, I think, 4 other states. Is it, Mark?
Right, yep.
And he also co-counsels with attorneys from all over the country for elder law and Medicaid planning situations. He is a frequent speaker at different NALA conferences, Wealth Council, Stetson, things of that nature. He is a certified elder law attorney, and his practice is primarily devoted to Medicaid planning as well as elder law. If you have any questions during today's webinar, feel free to type those into the questions tab of the GoToWebinar dashboard. And I also have supplied a copy of today's materials from a copy of the slides in the handouts portion of the GoToWebinar dashboard as well. If you want to learn more about why you should consider working with Ashbur, we have actually next year is going to be my 20th year of experience working with elder law and estate planning attorneys. We also have Stuart Otto, who joined our team about a year ago, and he's been working with elder law and estate planning attorneys for 10 years. And our newest team member, Alyssa, worked for an elder law attorney in Pennsylvania for 7 years as well. So between the 3 of us, we have over 37 years of experience doing this type of planning, specifically helping clients to qualify for Medicaid through the use of an annuity. We do offer complimentary case analysis, so we will help you to determine the optimal amount to put into an annuity contract that we offer, the term of the annuity that can be considered, and then which assets your clients may consider annuitizing. This is specifically important in cases where we have situations where clients have existing non-qualified annuities that we may do a 1035 exchange with, or if we have qualified assets like we're going to be talking about today, when we should consider annuitizing those and using those to purchase a Medicaid compliant annuity. I like to say that it's the best experience that your office will have purchasing annuities. We do offer top-notch customer service. We normally get back to you same day with a proposal and pre-filled application documents to make it as simple as possible for you and your clients to work with us on your annuity purchases. We do work with A-rated insurance carriers as well, so your clients don't have to be concerned about using a carrier that may not have a certain rating that they're looking for. Now we're going to jump into the actual presentation of the Medicaid asset limitations for both a single person and a married couple. When we have just a single client, which we're going to be talking about 2 different case studies dealing with a single person today, normally the most common amount of assets that that person can keep is around $2,000 in their name. So if you have a situation where your state counts retirement accounts or qualified funds and the value exceeds a $2,000 amount, then we're going to have to do planning, because the asset limitation would be $2,000 in most states. There are some states that have a slightly greater amount. Illinois is at a number around 20,000, and then Missouri is around 6,000 for an asset limitation. But if you have any questions about that, you can always visit our website at ashbur.com to check out what your state limits the amount of assets to. If we are dealing with a married couple where one spouse is going to be applying for Medicaid and the other spouse is at home, or they're considered to be the community spouse, usually the Medicaid applicant, again, is going to only be able to keep around $2,000 of assets, and the community spouse or the spouse that is not applying for benefits is going to be able to keep around 1/2 of the couple's countable assets as of the snapshot date up to an amount of $154,140. This does vary by state. Some states don't make us count or cut the number in half to get the amount of community spouse resource allowance. They are simply considered a maximum state that let the person keep the maximum amount of $154,140. But more states do total up the total assets of the married couple and then divide that number in half to determine the amount of protected resources and cap the amount at $154,140. When we look at what Medicaid planning actually is, it really is just a term that involves either spending down or otherwise trying to protect a person's assets so that they can meet the financial criteria for Medicaid qualification. And we can really divide Medicaid planning into two different types. We have pre-crisis planning, which is normally going to occur 5 years out of the person having to apply for Medicaid. So we have people that are still pretty healthy. We don't anticipate them needing to qualify for Medicaid in the near term, or we don't anticipate them needing care in the near term. And then the second type of Medicaid planning is going to be what we're talking about today, the crisis planning, which really involves somebody who is already in need of care, and we're trying to do planning today to preserve as many assets as possible and also qualify that person for government benefits so that they can save as many assets as possible. Whether we are pre-crisis planning or crisis planning, one of the most difficult assets to plan with is going to be qualified or retirement funds, and that really is related to the income taxes that are due if we change ownership on a qualified account, or if we are trying to liquidate a qualified account that the client has never paid taxes on before. There is going to be a tax consequence of doing that, and that's why doing pre-crisis planning when you're trying to transfer assets into an irrevocable trust to start a 5-year look-back period is extremely difficult when we have a lot of retirement assets. So in a situation like that, we may look to like a hybrid long-term care insurance policy that would help to leverage the client's existing assets and do that in a way where we can fund the policy with a qualified asset instead of having to liquidate the account and transfer into a trust. And that's all going to be contingent on whether the client is healthy enough to qualify for one of those policies or not. So most of you have heard that we have 10,000 baby boomers turning age 65 every single day. That's over 300 per hour, 73 million over the next 10 years. And this group really controls the majority of the 29 trillion of qualified retirement or pre-tax accounts out there. And this really is a result of most employers no longer offering pension plans, but now offering a 401k or a 403b, things of that nature, where you are likely running into clients that have retirement accounts, and we need to know how we can plan with those in the most tax efficient way without having to just liquidate those and pay all the taxes on the retirement account. The different types of accounts that are included in the 29 trillion is traditional IRAs, 401ks, 403bs, 457s, thrift savings plans. Qualified retirement accounts have doubled since the year 2000, and since the year 2007, qualified retirement accounts have increased by 18 trillion. So it's no wonder why most of your clients that are trying to do this type of planning will have some type of retirement account, and we need to know how to plan with it. The different types of retirement accounts or plans include a traditional individual retirement account or an IRA, We have Roth IRAs, 401ks, and 403b plans. The general income tax treatment on non-Roth accounts, so this is going to be like your traditional IRA account, 401ks or 403bs, is going to be that there's pre-tax contributions into the plan. So taxes are not paid prior to funding a non-Roth account. There are not any income taxes on the earnings as the account grows over time, but then there would be ordinary income upon receipt of the non-Roth account, whether it's liquidated or if the account is annuitized, then there would be taxes that are going to be due as the annuity makes payments over whatever specified term we would choose. If we instead look at a Roth account, this is going to be a type of retirement account that is funded with post-income tax contributions. So taxes have already been paid on the contribution into the Roth account. Again, there's not going to be any income tax on the earnings, and there is not any income upon receipt of the Roth IRA or Roth account if we were to liquidate that or annuitize it. And so it's important, if we have a client that has a retirement account, to know whether it's Roth or a traditional or non-Roth account, and then know whether there's going to be income taxes that are due if we annuitize that or if we were to liquidate the account. The different types of assets that can exist within retirement accounts include bank accounts or credit union accounts. So clients can have a CD at the local bank that is funded with pre-tax dollars, or is a Roth IRA CD at their local bank. We can also have investment or brokerage accounts that are either non-Roth or Roth. And then annuities, which we're going to be talking primarily about today, can be funded with either non-Roth or Roth accounts as well. And then finally, there are some self-directed accounts, like for alternative investments. Usually it is related to real estate, that can also be another type of asset that is owned within a qualified account. When we're talking about Medicaid planning and retirement accounts, each state is different in terms of how retirement accounts are going to be treated for Medicaid planning purposes. States are going to take one of the three positions. They're either going to completely exempt the retirement account and count the account as completely non-countable. So if you're in a state that completely exempts the retirement account, this makes planning a whole lot easier, because you don't have to do any planning related to the retirement account, and you can really be looking at just the non-retirement accounts for planning when it comes to Medicaid spend down. Otherwise, states are going to exempt the IRA if the person is receiving regular systematic payments or they're of RMD age. And then finally, the states are also going to consider accounts to be completely available or accountable asset. And this may be different for a community spouse and an institutionalized spouse. So a state may consider the community spouse's retirement account to be non-countable, but will consider the institutionalized spouse's account to be a countable asset. Planning is obviously going to be the most complicated in states that consider the retirement account to be an available or accountable resource. Most of the country does treat qualified accounts this way. There's 40 states that consider the either one or both of the spouses' retirement accounts to be countable. It's going to be most complicated because of the income tax consequences related to retirement accounts, which I talked a little bit about. This is a map here that's showing the states that consider the institutionalized spouse or the Medicaid applicant's retirement accounts to be countable versus exempt. you see that most of the country is colored in white, which means that most of the country does consider the Medicaid applicant's IRA to be a countable asset. The states that are in orange are the states that consider the Medicaid applicant or the institutionalized spouse's retirement account to be exempt, either completely exempt or exempt if they're receiving their systematic payments, regular payments under the RMD calculation. So planning for a person that is going to be applying for Medicaid when they do have a retirement account that exceeds the $2,000 asset limitation is going to be an important consideration, because most of the country does treat the Medicaid applicant's retirement account as an available asset that we have to do something with. This map is showing the community spouse retirement account. So the spouse that would not be applying for benefits, which states consider the community spouse's IRA to be countable versus exempt. You're seeing more orange states on this slide here because more states are going to consider the community spouse's retirement account to be either completely exempt or exempt if the person is receiving their regular RMD payments or systematic payments under the annuity, under the IRA contract. And then again, the states that are in white, the community spouse's retirement account are going to be countable if we don't do some kind of planning with it. You'll notice Wisconsin is where Mark practices primarily, is a state where the institutionalized spouse's retirement account is considered countable. But then when we go over to the community spouse's retirement account on this slide, the community spouse's account is going to be an exempt asset. Pennsylvania is the same way as well. So if you practice in one of those states, just know that you won't need to necessarily do a whole lot of planning for the spouse's IRA, but if you have a single person that's applying for Medicaid, then we would have to do planning related to that. Mark, did you have anything to add up to this point?
No, I think we're, I think we're good.
Okay. If we move on to the different types of annuity contracts, we have deferred annuities and we have immediate annuities. Deferred annuity is almost always going to be considered an asset for Medicaid qualification purposes because the annuity is going to be revocable and it can be surrendered for a lump sum of cash. So it's going to be similar to a client investing money at a local bank in a CD where they're investing a lump sum of money for a period of time. It can either be withdrawn or it can be annuitized at a later date. So a deferred annuity is going to be considered an asset because there is cash value associated to a deferred annuity that the client would have access to. Whereas if we look at an immediate annuity, the immediate annuity is going to be a client putting a lump sum of money into an annuity contract that's going to be annuitized within 1 year of the purchase, meaning that the client is going to start receiving payments from the immediate annuity within 1 year. It's going to pay them both the principal that they put into the annuity plus a certain amount of interest, and it's going to be structured for either a specific period of time, or some immediate annuities are structured to pay out for the person's life expectancy, or it's a life annuity that's only going to pay out until that person passes away. Generally, the election to annuitize an immediate annuity is going to be irrevocable and it cannot be undone. So once we have invested a lump sum of money into an immediate annuity, it's going to be strictly considered an income stream because there's no longer any cash surrender value associated to the immediate annuity contract. It cannot be surrendered and it is considered an irrevocable choice that the client makes to receive payments for a specific period of time or for their life. A Medicaid compliant annuity is a specific type of immediate annuity that is converting a lump sum of countable assets into an income stream. A Medicaid compliant annuity that is purchased with non-retirement funds or non-IRA funds must meet all of the requirements that we talk about pretty much every webinar, where the annuity must be irrevocable, non-assignable, actuarially sound, make equal payments without any deferral or balloon payments. And then usually the state Medicaid agency must be listed as the beneficiary, unless there is a community spouse, a minor or disabled child. Then there are situations where we're going to name the minor or disabled child or the spouse before the state Medicaid agency. Annuities that are purchased with retirement funds do not need to meet all of the requirements that you see on the screen, the 5 requirements of irrevocable, non-assignable, equal payments, things of that nature. Mark, did you want to talk a little bit about the DRA language related to annuity contracts?
Yep, I can do that. And just as a little point of discussion before I get into this, it's important to know, it's important to understand annuities just by and of themselves without, you know, the assistance of somebody like Amber, are incredibly tough and difficult assets in terms of Medicaid eligibility. And the reason for that is because of these laws that we'll go over. But it's incredibly interesting to think about a particular financial product. Let's take an annuity in this case as being income for purposes of Medicaid eligibility, as an asset for purposes of Medicaid eligibility, and a gift for purposes of Medicaid eligibility, all at the same time. And that is what you run into with in an immediate annuity that's not done the right way, in a Medicaid compliant way. A deferred annuity, as Amber explained what that is going to be an asset. And interestingly enough, it is possible, it is very, very possible that it could also be construed as a gift because of the language that we're going to go over now. So Medicaid is a joint federal and state program, and that means it's funded with federal dollars and also with state dollars. And every state is obligated to comply with federal law if it wants to receive federal dollars. And they all do, so they all want to comply with federal law. One of the Medicaid laws one of the federal Medicaid laws that are out there is 42 USC 1396 P C1. And this is really getting into where we talk about transfers of assets for less than fair market value, which gets into the notion of gifting. And so if you look at the first portion of this slide, which is capital F, it's C1, capital F. If you're going to purchase in an annuity, it's going to be treated as the disposal of an asset. Okay, that's a gift for less than fair market value, unless you name the state as the beneficiary, or unless there's a spouse or a disabled child. So, you know, if you have a client who purchases an annuity, just that act alone, may be a gift for purposes of Medicaid eligibility. So you have to be mindful of, if you're going to purchase an annuity, who's going to be the beneficiary? Because if you don't do that right, then that could be treated as a gift. So second, you've got C1 capital G. And capital G says, with respect to the transfer of assets, okay, they're getting, again, transfer for less than fair market value. Assets includes the purchase. And so you're going to have made a transfer of assets unless, and then we get into a single I for a 1, or the annuity is described in section B or C of 408. Well, Amber already went over that 408 is the Internal Revenue Code section for IRAs. So if it's an annuity described in subsections, well, it's B or Q of section 408, well, then it's not a transfer of assets. And that's all that it says, or it's the proceeds of an account. Okay, all right. So good enough. We've kind of got that. And this is what talks about retirement funds or qualified money or tax deferred funds in a retirement account. Your IRA, your 401k, your 403b. This is your retirement provision as it pertains to annuities. Now, what if it's not a retirement account? Or what if the money is not pre-tax or deferred income for income tax purposes and it's just regular money? Well, then you drop down to the bottom part of this slide and the 2 I's, then that's where, if you go back to Amber's previous slide, the annuity has to be irrevocable, non-assignable, actuarially sound, and provides equal payments with no deferral or balloon. So that section, the 2 little I's, is for non-retirement accounts, and the 1 little I is for retirement accounts. And there's not a lot of restrictions or provisions in the 1 little I. It has to be in an annuity inside of a retirement account, presumably an IRA, because that's code section 408. But that's the big difference. If it's an IRA fund, you don't have to have all the requirements that are there in a non-IRA fund, where it's listed in number 2. Federal law is very, very clear that an annuity in an IRA or in a retirement account is different than in an annuity that's not in a retirement account. And so that's an important distinction for us as planners, as attorneys, in terms of being able to help our clients with these tougher assets, which are retirement accounts.
Thank you, Mark. So just to kind of summarize what Mark was saying, if the Medicaid compliant annuity is purchased with money in the retirement account, then usually we're referring to it as an IRA, MCA. The annuity must name the state as the beneficiary, but it does not need to be actuarially sound, make equal payments, and it can include a balloon payment. So an IRA, MCA can be structured longer than life expectancy, does not need to be actuarially sound, and it can make a balloon payment. And again, this slide is just summarizing the non-IRA MCA and all of the language that must be included in the contract versus an IRA MCA. We did include the irrevocable and non-assignable language on the side of the IRA MCA to avoid the account being considered an available asset or an asset that could be transferred to a third party like JG Wentworth or Peachtree, purchased on the secondary annuity market. So that is something that we added to the IRA MCA as really just being more conservative with the type of annuity that would be purchased, so that is not considered an asset or a resource. The different types of assets that can be used to purchase a Medicaid compliant annuity is really any type of cash asset, money that's in brokerage accounts or stocks and bonds. Those would have to be liquidated to cash before we transfer into a Medicaid compliant annuity, but then also we can use whole life insurance policies or non-qualified annuities if we're trying to do a 1035 exchange. And then what we're going to be focusing on for the rest of the presentation is really on IRAs or retirement accounts that we're trying to transfer into an IRA MCA. We're going to start out talking first about a single person or a Medicaid applicant that is applying for benefits who does not have a spouse. So if we are looking at the different planning opportunities that are available for just a single person that does have retirement accounts that are going to be considered accountable asset, then we have the option of doing first a gift and annuity plan, which last month's presentation was all about about non-retirement accounts, where we were just doing your standard half a loaf type plan, the gift and annuity strategy, where the half of the money was gifted and then we used the other half approximately to purchase an annuity to pay through that private pay period. We would also have the option of doing an IRA MCA, and then the final option would be to do a combination of options 1 and 2, so do a gift and annuity plan and an IRA MCA at the same time. When we are doing a gift and annuity plan, the goals that we're trying to achieve is to allow a single Medicaid applicant to make an immediate wealth transfer to their intended beneficiaries and then qualify for Medicaid at the end of the ineligibility period associated to making a gift. And this is really where the short-term annuities are going to be beneficial to your clients in order to have an annuity term that is going to match whatever the private pay or the penalty period would be. So if we're doing a 5-month penalty, we would also purchase a 5-month annuity to allow that person to privately pay during the private pay period associated to the gift. When we talk about gifting retirement accounts, this is a question that we get frequently. There's not a way to gift a retirement account without the person having to pay the income taxes associated to the amount that is going to be gifted or transferred out of the person's name. So anytime that we would be changing ownership of the qualified retirement account, there is going to be a tax consequence associated to changing ownership. So there's really not a way to gift the retirement account without having to pay those taxes prior to making the gift. If the applicant does not live through whatever penalty period we have created as a result of gifting assets, then they really aren't gaining any economic benefit from Medicaid until that private pay period is over with. And so life expectancy is always going to be a consideration that we would take into account, because we don't want to have a client incur a super long penalty period associated to making a gift and then pay the income taxes associated to liquidating a retirement account or gifting a retirement account and then not have them live through that private pay or penalty period that was resulting from the gift. If we look at our first case study example, we have Jane Doe, who is 86 years of age. She was recently admitted to a nursing home at a rate of around $265 a day, or $8,000 a month. Her daughter, Jan Apple, has a broad and comprehensive durable power of attorney to act on Jane's behalf. Jane has around $125,000 in a bank account after spending down on prepaid funeral and other expenses, and has around $205,000 remaining in her retirement account. Jan anticipates that Jane could be in the nursing home for some time, and Jane's monthly income from Social Security and a small pension is around $2,000 a month. So if you look at Jane having to pay $8,000 per month private pay and only having around $2,000 a month of income, she's short over $6,000 a month from being able to meet her current expenses. The solution that we considered for Jane in this case was that she was going to make a gift of around $124,000, which would leave her around $1,000 in her bank account, which is below the $2,000 asset limitation that she would have in her state. Because we are making a gift intentionally, this is going to create a penalty period or a private pay period of, right around 13 months. With her IRA valued at around $205,000, we're going to have Jane purchase an IRA Medicaid compliant annuity that's going to pay her around $5,400 per month for 13 months. We did a 13-month term in this case to match the 13-month private pay period that Jane has as a result of making the gift. The annuity would have a balloon payment in this case of around $135,000, and that's going to be paid in the final month of the annuity. And the payment from the $5,400 a month payment from the balloon is going to be enough to satisfy Jane's annual required minimum distribution for IRS purposes. And really the goal behind using the balloon style annuity in this case is not having to liquidate the $205,000 IRA account, because if you just use simple math of dividing your $205,000 retirement account by the 13 months that Jane would have to privately pay because of the gift, that would be a monthly payment without a balloon of around $15,800, which is going to well exceed what the shortfall is at $6,000 per month. So really the balloon payment is going to allow for Jane to not have to do a level payment on the annuity and still meet the income shortfall test of Jane being otherwise eligible for Medicaid. If Jane is still living in the nursing home after the 13-month IRA Medicaid compliant annuity comes due for around $135,000, Jane could withdraw around $91,600 from her IRA, pay around $17,000 in estimated federal and Wisconsin income taxes, and then gift around $74,600. This is also going to incur an additional penalty period of around 8 months. So we could then use the remaining amount in the IRA balloon, or the $43,200 that would be remaining, and use that to purchase an 8-month annuity again for the $5,400 that Jane would be short each month from incurring this 8-month penalty, and also allowing her additional income to be able to meet the private pay requirement. If Jane is still living in the nursing home after the 8-month time frame, then she would be eligible for Medicaid because she has served the penalty periods associated to the gifts that she has made over the 13 months and then also the 8-month time frame. The advantages of the IRA MCA was that Jane was able to make gifts to her intended beneficiaries and use the IRA funds to pay for her care. If the state is named as the beneficiary, which it would have to be in order for the IRA MCA to meet the DRA requirements, the IRA MCA is being used to privately pay for Jane's care, so the state would not have a right to recover in that case, and so the contingent or secondary beneficiaries would be entitled to whatever amount is remaining in the IRA MCA after, if Jane were to predecease the term. Mark, did you have anything that you wanted to add on that example?
No, other than I think it's a great example and something to keep in mind, because you know, if there's a payback to the state, you know, in this odd way, it's actually saving your client a little bit of income tax, or your client's family members a little bit of income tax, because that payment to the state, you know, they're going to receive the payment from the IRA or the IRA annuity. And, you know, whether the state of Wisconsin or the state of Delaware has to recognize that as income for federal income tax purposes, you know, it doesn't matter, and we don't care. And it's not going to your client or to your client's beneficiaries. And if you didn't do this, they would have to withdraw the money in order to privately pay. And so it's a deferral for having to pay, and it's using, you know, pre-tax money to pay the state, and that's better than going to your client to have to recognize income, or to their family members to have to recognize income as well.
Okay, perfect. Now we have a change in the circumstance of our single individual. So in the first example, we had some non-qualified assets that we were using to make a gift. If we instead consider a situation where we have Jane Doe, who has only an IRA valued at $500,000 with no other non-qualified assets, then and we assume that she has a checking account balance of say $1,000, that's not going to put her over the asset limitation. All the other assets have been spent down, so we're really dealing with an IRA in this case. And Jan, the daughter, shares with you that she places a good faith estimate that she anticipates Jane living for at least 2 years. The nursing home invoice has been paid through October of this year, and she's really seeking November 1st eligibility for Medicaid qualification. If we look at this example now of using the $500,000 IRA, we would have Jane purchase an IRA Medicaid compliant annuity that would pay her around $125 per month for a 12-month period. The final balloon payment would be made in month 13. The IRA MCA would make the first payment in November of 2024, so 1 month after the annuity is purchased, and it would make a final payment in November of 2025. The final balloon payment in month 13 would equal approximately the amount that was put into the annuity at $500,125. Jane would start receiving Medicaid benefits immediately in November of 2024, because we have converted what Medicaid considers to be an asset, or the $500,000 qualified account, into an income stream that's going to meet the requirements of Medicaid. So in this case, we're not making a gift, and instead Jane would immediately start receiving benefits from Medicaid. And if we consider Jane still being alive when the balloon payment comes due in month 13, then we would have Jane withdraw the amount that is due for her 2025 required minimum distribution because she is over RMD age. And depending on the state that Jane resides in, we would have to do additional planning with the balloon payment. We could consider doing a gift and annuity plan, or we could consider the transfer to a D4C trust if that's permitted in your state. Mark, you can talk a little bit more about that if you wanted to, because I know that's an option in Wisconsin.
Sure. So you know, if Jane is still living, and that's a terrible thing to say, but it's also a reality of our practices, you know, then Jane is going to have to take her 2025 required minimum distribution, and if it's $500,000 account, it's not going to be minimal. I mean, it's going to be a decent amount. And so something's going to need to be done with that. And, you know, one thing to check on is to see if your estate does allow for individuals who are over age 65 to transfer assets into a pooled and community trust, a D4C trust, and that may not be treated as a transfer that'll get you a penalty period. As Amber mentioned, Wisconsin is one of those states that allows that. So as an example, if Jane Doe lived in Wisconsin and we got to November of 2025, we'd pull out of her ballooned annuity what we need to make sure she complies with her 2025 RMD. We'd probably put that into one of our pooled and community trust arrangements that we have here in Wisconsin, a D4C account. And then with the remaining amount inside of the IRA, we would probably be on the phone with Ashburn and with Amber to do yet another MCA IRA, a Medicaid compliant annuity inside of an IRA, and it would be very similar to the first one.
Okay, perfect. So in this case, upon Jane passing, assuming she were to pass away during the term of the annuity, the state would be the primary beneficiary. They would be entitled to collect for the amount that they provided on Jane's behalf in this case, because she was immediately eligible for Medicaid. And so the state would have a right to recover, and they're going to recover at the Medicaid reimbursement rate versus the private pay rate. So then anything after the state is paid would go to the remainder, the secondary beneficiaries, which is most time the children. The advantages of the IRA MCA was that we were able to obtain immediate Medicaid eligibility for Jane, and if there is a payback to the state, then Jane is using pre-tax dollars, like Mark mentioned, to pay back the state versus using after-tax dollars if we were to put the whole IRA through the taxation system prior to doing an annuity plan. Mark, actually, we had a quick question come up here, and I don't know if you've ever run into this situation. We have a question about a client moving to another state while serving a private pay or a penalty period associated to a gift. Have you come across that before?
I have, and it's tough, and this is the tough part about Medicaid, and the fact that it's really not federal. It's federal. Again, Medicaid is a joint and federal program. The states, however, are allowed to have their own and administer their own individual Medicaid programs. So we have 50 different Medicaid programs in the United States. And so if you're in one state and you do a bunch of work and then a client moves to a different state, you're going to have to do the application, that state's application, and you're really not going to get any credit for a penalty period served in another state. And I don't think that there's any provision in the federal law to allow for that. So my experience is unfortunately it's best to not move, because you could get hit with a double penalty period. Because my experience has been you don't get credit for penalty period served in one state in a new state. The new state's going to take in the new application, and they're going to apply the rules, that state's rules.
Okay, perfect. Thank you. If we move on to a married couple situation and we look at the planning opportunities when we have an applicant and a community spouse that has retirement accounts that are both considered countable assets, we'll go through the different options that institutionalized spouse or the Medicaid applicant has when they have a retirement account and there is a spouse involved. So the first option would be for the Medicaid applicant to completely liquidate the IRA, pay the taxes, and gift the remaining amount over to the community spouse so that the community spouse can purchase a non-IRA MCA. This would be really kind of a last resort that we would suggest for people that have Medicaid applicants that own retirement accounts. The second option would be to purchase an IRA Medicaid compliant annuity in the name of the Medicaid applicant and have that income go towards their, be counted as the income of the Medicaid applicant, and then hopefully shift it over to the community spouse under the MIMNA calculation. The third option would be to use name on the check rule. So we're annuitizing the Medicaid applicant's retirement account in their name, and then naming the well spouse or the community spouse as the payee on the contract. This is allowed in many states, but then there's a handful of states that don't allow for us to use name on the check rule. So then you're really stuck with one of the other options if your state doesn't recognize the name on the check rule. The fourth option would be to use a marriage quadro, especially in states where the community spouse's retirement account are completely exempt, or if we want to increase the community spouse's income beyond the monthly maintenance needs allowance. The options when we have the community spouse's retirement account that is considered a countable asset, the first option would be to liquidate the IRA, pay the taxes, and purchase a non-IRA MCA, which we almost never suggest unless it's a really small IRA account, $5,000 or $10,000, just for simplicity. But then the second option would be to purchase an IRA MCA that is owned by the community spouse in order to convert the countable asset into an income stream. So if we quickly go through John and Jane Doe's example, we have John and Jane who are married. John is age 84 and Jane is age 83. John is the spouse that's in the nursing home paying around $9,000 a month. Jane is in excellent health for her age. They both have monthly income of around $1,500 per month. John and Jane both, they own their home together. They have $400,000 in non-retirement assets. John has an IRA that's valued at $500,000 and Jane has an IRA that's valued at $400,000. They would like to protect as many assets as possible, and they are applying for Missouri Medicaid, where Missouri is a state that counts both spouses' retirement accounts as a countable asset. So if we consider the solution for John and Jane Doe, we would move the home from being jointly owned over to Jane's name alone. We would use the non-retirement assets of $400,000 and let Jane keep the $154,140 as her community spouse resource allowance. We would then use the excess amount of non-retirement assets, which would be around 225,000 after they do some spend down of around 21,000. And we would have Jane purchase a non-IRA MCA to convert non-countable or non-retirement assets into an income stream for Jane. We would then have Jane also purchase an IRA MCA that is using her IRA valued at 400,000, and that could really be based on whatever payment terms she would desire as the community spouse. John, as the Medicaid applicant, he had an IRA valued at 500,000, and he would purchase an IRA MCA that's going to pay him around $125 per month for 12 months, and then the final balloon payment would be paid in month 13, and that's again going to be 500,000, 125 that would be paid to him in month 13. As a result of doing this plan, John would immediately be eligible for Medicaid. After the 13-month time frame, John needs to receive his RMD from his IRA, and then he would use the net proceeds to purchase another IRA MCA that's going to pay him around $125 per month. The RMD amount could be gifted to Jane as his spouse when he receives that from the IRA MCA. We're going to continuously renew John's IRA MCA if he is still alive when the balloon payment does come due. And then if we assume that John passes away and Jane survives him, then Jane would inherit the remaining balance of John's IRA MCA without having to pay any income taxes under the spousal rollover rules. And she would be able to really reinvest that money from the IRA MCA into her own retirement account, because she would be named as the primary beneficiary on his annuity, because a community spouse can be named as the primary beneficiary before the state if it is the Medicaid applicant that is purchasing the IRA MCA contract. So we had a question here about when the community spouse can be named as a beneficiary before the state, and it's really in the situation where the Medicaid applicant is the owner of the annuity. They can name the community spouse as primary beneficiary before the state. So in this case, there would not be any estate recovery because we have a surviving spouse that would receive the remaining annuity amount.
And just to go back, Amber, if you go back, one thing I'll just add is that, on the renewal, and I think you've covered this, but we always have to make sure that the RMD, that we're taking that when the annuity balloons, 125 per month is probably less than the RMD. So we're always going to have to take that out. And then, as suggested in number 7 there, that RMD is just gifted over to the spouse.
Okay, perfect. And I know we're running short on time here, so I'll just finish out. We were going to talk about funding of the IRA MCA and the 2 different options that would be available. We could do either a direct trustee to trustee transfer, or we could do the 60-day rollover option. It really comes down to how much involvement your client wants to have in the process. The 60-day rollover is a little bit more involved on the client's part as far as having to obtain the money from the current IRA custodian and then reinvest that money within a 60-day time frame, whereas the transfer process is going to be done pretty much between the 2 companies, and the client isn't actually going to take possession of the funds. One thing that I'll mention is that we're limited with the rollover to 1 rollover per 12-month period. So if there are multiple IRA accounts, then we would have to do the direct trustee to trustee transfer, because the trustee to trustee transfer, we can really do an unlimited number of those without any issue with the IRS. So if there are multiple accounts, then we would have to use the transfer process versus the 60-day rollover. And I know that we're pretty much out of time. I tried answering questions as they came up throughout the webinar, but if anybody has any questions after today's program, you can reach out to either myself, Amber Hines, and my email address is amber@ashbur.com. And then also I put Mark's information on here as well. He's willing to answer questions, or co-counsel if you have a situation that you need somebody to co-counsel with you. Mark, did you want to add anything? Sorry, I had to skip through.
No worries. I know we're getting towards the end, and I know we're both the type of people that want to be respectful of people's time, but thank you for attending. And if you have follow-up questions, Amber and I will be available for sure.
Okay. Perfect. Thank you, everybody, and be on the lookout for our November webinar topic that is coming up soon. Thank you and take care, everybody.